the rules. The First Amendment protects the freedom of speech. The government may not prohibit speech based on its content. That is our general rule. The First Amendment protects the freedom of speech. The government may not prohibit speech based on its conduct. Let's talk first about expressive speech, expressive conduct, and symbolic speech. Remember, the government may not do what? Prohibit speech. Based on what? Its content. But may they regulate speech? Yes. So first of all, let's talk about what expressive speech is. It is the obvious political speeches, any type of music, art, film, parade, and even using profanity is protected speech. Contrast, expressive conduct. For example, in the Tinker case, students wearing black armbands in school to protest the Vietnam War. That is expressive conduct. Okay, remember we said we cannot prohibit speech based on its conduct, but speech can be regulated if it places an incidental burden on speech. From the Tinker case, we get a regulation that places an incidental burden on speech is allowable if it is basically passes strict scrutiny related to 1, an important governmental interest, 2, unrelated to the suppression of speech, and 3, no more extensive than necessary. Okay, the government may not prohibit speech based on what? Its content, but they may regulate speech if there is what kind of burden? That's right, an incidental burden on speech. A regulation that places a incidental burden on speech is allowed if 1, it is related to, that's right, an important governmental interest. 2, that interest must be, that's right, unrelated to the suppression of speech. And 3, the regulation must be, that's right, no more extensive than necessary. 1, important governmental interest. 2, unrelated to suppression of speech. 3, no more extensive than necessary. And this is for a regulation that places an incidental burden on speech. Moving on, symbolic speech. Classic symbolic speech, burning the flag, burning a draft card. 2 prongs. What constitutes symbolic speech? The person has the intent to convey a particular message, and the message is likely to be understood by those who see it. 2 prongs, intent, 2, understanding. Number 1, that's right, intent to do what? Convey a message, and 2, understanding. The message is likely to be understood by those who see it. Can the government compel speech? No. The government may not compel, for example, students to salute the flag, say the Pledge of Allegiance. A state cannot compel its residents to have a license plate that says live free or die. The government may not compel speech. The government may not prohibit speech based on its content. However, the government may regulate if it places what kind of burden on speech? An incidental burden. And we have 3 prongs. The regulation must be related to an important governmental interest, unrelated to what? That's right, the suppression of speech. And it may be no more, that's right, extensive than necessary. And what's our 2-prong test for symbolic speech? Symbolic speech means the person has 1, intent to convey what? A particular message. And 2, the second prong is understanding. The message is likely to be understood by those who see it. And of course, no compelled speech. All right, let's move on to vagueness and overbreadth. Any law, general rule, any law regulating speech must not be vague or overbroad. Repeat, a law that regulates speech must not be vague or overbroad. What does vague mean? It means that it is so imprecise that a reasonable person could not determine what conduct was prohibited and what was not. If something is vague, it is so what? Imprecise. That what kind of person? A reasonable person could not do what? Determine what was prohibited and what was not. That's vague. Try to repeat the whole rule. A law that is void for vagueness is so imprecisely worded that a reasonable person could not determine what conduct was prohibited and what was not. Contrast, overbroad. Laws that are overbroad regulate more speech than is permissible. Repeat, an overbroad law regulates more speech than is permissible, such that it encroaches on individual rights or protected conduct. So the basic rule for an overbroad law, a law can be void if it's overbroad, regulating more speech than is, that's right, permissible. It may not encroach on, that's right, a person's individual rights or their protected conduct. Okay, so a law may be void for vagueness when it is so imprecise that a reasonable person could not determine what conduct was prohibited and what was not. And a law may be void if it is overbroad. It regulates more speech than is permissible, such that it encroaches on individual rights or protected conduct. One good example of vagueness is a law prohibiting any. All right, we're going to forget that case. The overbroad law is about loitering. Okay, now let's talk about speech that is content-based restrictions. What is our general rule? The government may not restrict speech based on what? Its content. The government may not do what? Regulate speech based on its conduct. Okay. There are two types of restrictions: subject matter regulations and viewpoint regulations. So a viewpoint might be a particular perspective, like protesting war. Subject matter speech regulations restrict speech based on topics. Subject matter equals topic. Viewpoint regulations equals perspective. Subject matter equals what? A topic. Viewpoint regulations equal, that's right, a perspective. Okay. Content-based regulations are subject to what kind of scrutiny? That's right, strict scrutiny. In general, the government may not do what? They may not restrict speech based on its conduct unless the government can prove that that restriction is narrowly tailored to further an important governmental interest. The government will argue that their content-based restriction is narrowly tailored to further an important, a compelling governmental interest. Narrowly tailored, compelling. That's our strict scrutiny. Okay. For example, let's talk about some laws that failed strict scrutiny. No political signs. Is that content-based? Yes, absolutely. You're restricting political speech. But what about if you ban all signs without a permit, but you have so many exceptions, like for ideological, political, or directional signs? Why will that fail strict scrutiny? Because it is not what? Narrowly tailored to further what? A compelling governmental interest. And the case here is Reed versus Town of Gilbert. Remember, they had a ban on signs without a permit, but they had so many exceptions, like for directional signs, political signs, that that law failed strict scrutiny. The government could not prove that it was narrowly tailored to fit a compelling governmental interest. Okay. What about Booz versus Berry? We have a law that prohibits displaying signs within 500 feet of a foreign embassy if the message brought the government associated with that embassy into public dispute. Okay, that's a lot of words. Booz versus Berry. What's the law say? The law says you can't display a sign that disparages a foreign government within 500 feet of that government's embassy. That failed strict scrutiny. It was not narrowly tailored to further a compelling governmental interest. Booz versus Berry. Okay, so we talked about signage. Let's talk about another category that's commonly tested on the bar, and that is hate speech. Hate speech is protected if it's not fighting words or a true threat, which we will get to in a moment. Hate speech is protected. For example, the classic case here is RAV versus the City of St. Paul, cross burning. That is hate speech. It is protected. Or Snyder versus Phelps, protesting the United States' involvement in the war in the Middle East by picketing a Marine's funeral. That was protected. Why? Well, this Snyder versus Phelps is also used as an example of a time, place, and manner restrictions because the protesters have obeyed the laws, kept the required distance away and all of that stuff. But remember, hate speech is protected if it's not fighting words or a true threat. Hate speech is what? Protected. If it's not a true threat or it is not, that's right, fighting words. How about disparagement or scandalous speech? Is that protected? Yes. Why? Okay, perfect example, the case Mattel versus Tam. Remember, this is an Asian American band called, guess what? The Slants. And they were refused a trademark because the trademark office refused to issue a trademark that disparaged a particular class of persons. The court ruled that disparagement or scandalous speech is protected because what offends one person is not offensive to another, and it's impossible to objectively define. Mattel versus Tam. Okay, let's go through that again. Content-based restrictions are subject to what kind of scrutiny? Strict scrutiny, which means the government must prove the regulation is narrowly tailored to further a compelling governmental interest. So we have examples of signage, Reed versus Town of Gilbert. We've got a ban on all signs without a permit, but there's so many exceptions that permit directional signs, political signs, that it failed strict scrutiny. Or Booz versus Berry. You can't display signs disparaging a foreign government close within 500 feet of their embassy. That was too much restriction on speech, not narrowly tailored to further compelling governmental interest. Cross-burning, hate speech is what? Protected, so long as it is not, that's right, fighting words, or that's right, a true threat. Cross-burning, what case is that? That's right, RAV versus the City of St. Paul. And what about Snyder versus Phelps? Protesting the United States' involvement in war by picketing a Marine's funeral? Ouch, but that was protected speech. Hate speech is protected so long as it is not fighting words or a true threat. Another example that is good is violent video games. Those are protected. Okay, disparagement. Mattel versus Tam, the Slants. Why is that protected? What offends one person is not offensive to another and is thus impossible to objectively define. Why is disparagement protected? What offends one person may not offend another person, and thus it is impossible, that's right, to make an objective definition, Mattel versus Tam. Okay, so we just talked about content-based regulations, which are subject to strict scrutiny. Why? Because the government may not restrict speech based on its content. We gave some examples: signage, hate speech, disparagement. Now, let's talk about content-neutral regulations. We brought up Snyder versus Phelps as an example of the classic TPM, time, place, and manner restrictions, are generally upheld. Time, place, and manner restrictions are generally valid. Okay, we've got 3 prongs here. The government has to have a significant interest unrelated to the suppression of speech. 2, the means must be narrowly tailored. And 3, we must offer ample alternative channels of communication. Okay, time, place, and manner restrictions are generally valid. This is our general rule. Our 3 prongs are: the government has what kind of interest? A significant interest, and it has to be, that's right, unrelated to what? That's right, the suppression of speech. What about the means? Narrowly tailored and leaving open ample alternative channels of communication. Time, place, and manner restrictions are valid if there is a significant interest unrelated to the suppression of speech, the means are narrowly tailored, and ample alternative channels of communication are offered. Okay, let's apply this to Snyder versus Phelps. We have an organization picketing a Marine's funeral. The government has a significant interest in keeping the peace, and so they're going to keep those protesters far enough away not to disrupt the funeral. It was narrowly tailored, and ample alternative channels of communication were offered. The protesters could have protested anywhere that was not within a certain distance of the funeral. Okay, so remember, when you're looking at a content-based neutral regulation, what's the government always going to argue? The government will always argue that it's a time, place, or manner restriction and thus constitutional. And what's the challenger going to argue? That's right, they're going to argue that this is a content-based regulation and should be subject to what kind of scrutiny? Strict scrutiny. So when you encounter what appears to be a content-neutral regulation, the government is always going to argue what? Hey, this is just a time, place, and manner restriction. We have a significant interest. It's narrowly tailored. We're leaving open ample alternative channels of communication. But the challenger will argue that it is content-based. So the government must prove it is narrowly tailored toward an import to further a compelling governmental interest. Okay, so let's talk about a couple of examples here. Okay, so standing on a public way, within 35 feet of the entrance to an abortion clinic. Was this related to suppressing speech? Were there adequate alternative channels of communication? Okay, what's the government always going to argue? It's a time, place, and manner restriction. What did the challenger argue? It's a content regulation subject to strict scrutiny. Okay, a couple other examples. Permits. You can't, okay, remember, political canvassing is historically protected under the First Amendment. So do you think an ordinance that prohibited canvassers from going door to door without paying for a permit and registering their actual identities, do you think that is going to pass strict scrutiny? Heck no. You can't prohibit political canvassing door to door. You can't force people to register their actual identities because anonymous speech is protected. Okay, so let's keep it simple here. A content-neutral regulation, the classic example is a time, place, and manner restriction. The government must have a 1, significant interest unrelated to the suppression of speech. 2, the means must be what? That's right, narrowly tailored. And the government must provide what? Ample alternative channels of communication. The government's always going to argue that something's a TPM regulation, and the challenger's always going to argue that it is content-based and thus subject to strict scrutiny. Okay, moving on. So we just covered content-based versus content-neutral regulations. Now, let's talk about forums. Okay, so the forum doctrine relates to content-based and content-neutral regulations. Let's first talk about what type of forums, and then we'll talk about regulations. First of all, we have our traditional public forum, and that is a place that is traditionally open for speech: the streets, the sidewalks, parks. Then we have our designated public forum. This is an area the government has opened for speech and may close this area at any time. What about a limited public forum? This is just a type of designated public forum, but a limited public forum might be a place like a school. And then we have a non-public forum. What's a non-public forum? It's not a private forum. Don't confuse the two. A non-public forum is something like a hospital, an airport, a jailhouse, a polling place, a military base. And finally, we have a private forum. A private forum, remember, the First Amendment prohibits government restriction of speech. If you are on private property, speech may be restricted as much and as no matter what and however. You go to a mall, that's a private forum. Speech may be restricted or prohibited in any way. Okay, so let's talk first about our traditional public forum. This is a place, remember, that the government has done what? It's traditionally open for speech, so the restrictions are high. Political speech in a traditional public forum has what kind of protection? That's right, absolute protection. Any law that affects speech in a traditional public forum has to be content neutral, subject matter neutral, and viewpoint neutral, and pass strict scrutiny. Any law restricting speech in a traditional public forum has to be 1, content neutral, 2, subject matter neutral, and viewpoint neutral. We could abbreviate this CSV. C for content neutral, S for subject matter neutral, and V for viewpoint neutral. Traditional public forum, any law must be what? Content neutral, subject matter neutral, and finally, viewpoint neutral. And it must pass strict scrutiny. It is hard to pass strict scrutiny in a traditional public forum. It must serve a compelling state interest, narrowly tailored to meet the needs of that interest, and leave open, what do you think? For free speech, we always have to leave open ample alternative channels of communication. Okay, traditional public forum. What does the law have to be? Content neutral, subject matter neutral, viewpoint neutral. Only restrictions allowed if the government can prove what? They serve a compelling state interest and are narrowly tailored. And they leave open, the government must leave open, that's right, ample alternative channels of communication. Okay, so moving on, a designated public forum. What's a designated public forum again? That's right, an area that the government has opened for speech, but they may close it at any time. This might be, say, a library meeting room. All right. A designated public forum may be closed, but as long as it's open, it gets the same protection as a traditional public forum. A designated public forum, what is it? The government has opened that area for speech. They might close it, but as long as it's open, what kind of protection does it get? That's right, same protection as a traditional public forum. So any law must be what? One. That's right, content neutral and subject matter neutral and viewpoint neutral. And it must pass what? Strict scrutiny and leave open ample alternative channels of communication. So our traditional public forum and our designated public forum. The only difference is that a designated public forum is an area the government has what? Open for speech, and it might close. You can't close the streets, but you can close a library's public meeting room. Moving on to a limited public forum. Remember, this is just a type of designated public forum. There are a few. This might be a school. Okay, why would a school be a limited public forum? Well, you might limit speech in a public school based on speakers conducting school-related activities. Basically, if it's a designated public forum, it's just like a traditional public forum. Strict scrutiny. If we have a limited public forum, like a school, public school meeting room, restrictions have to be viewpoint neutral. And in a school, the government may discriminate against classes of speakers or types of speech. Rational basis review, rational, legitimate. Limited public forum, rational basis review, rational, legitimate. Designated forum, strict scrutiny. As long as the area is open for speech, narrowly tailored, compelling. Traditional public forum, always held open for speech. Strict scrutiny, narrowly tailored, compelling. What about a non-public forum? Reasonable restrictions are okay. Do we want people speaking out in hospitals, jailhouses, polling places, airports, and military bases where safety is an issue? Reasonable restrictions are okay in a non-public forum. Basically, the law has to just pass rational basis review, or even less, rationally related to a legitimate public interest. Okay, let's go through that one more time. Traditional public forum is, that's right, a place the government has traditionally held open for speech, and it may not prohibit speech based on its content. Any law must be one, CSV, content neutral, subject matter neutral, viewpoint neutral. The law must pass strict scrutiny. In other words, the government must prove it is narrowly tailored to further an important governmental interest. And the government must leave open what? Oh, yes, ample alternative means of communication. Okay, does this mean that the government can't impose time, place, and manner restrictions? No, they can always do that. Okay, what about a designated public forum? Define a designated public forum. That's right, the government has opened that area for speech, but they might close it. What degree of protection do we get in a designated public forum? The same as a traditional public forum. The law must be CSV, content neutral, subject matter neutral, viewpoint neutral. It must pass strict scrutiny, narrowly tailored, compelling, and leave open, that's right, ample alternative channels of communication. Can we impose reasonable time, place, and manner restrictions? Yes. Okay, what about a limited public forum? Rational basis review. Rational basis review. Rationally related to a legitimate public interest. Rational, legitimate. Limited public forum, rational basis review. Okay, so what does this mean? Rational basis review, remember, is highly deferential to the government. The burden is on who? the challenger to show that the law is not rationally related to a legitimate public interest. Okay, so can one limit access to a public school meeting rooms to say school board matters or school matters? Certainly. Limited public forum equals rational basis review. Non-public forum, rational basis review. A non-public forum is, what the heck are we talking about? A military base, a hospital, a jailhouse, a polling place, an airport. That is a non-public forum. And all we need is remember, rational basis review, highly deferential to the government. The challenger must prove it is not rationally related to a legitimate public interest. And finally, we've got a private forum, private property. Speech can be prohibited, no limitations. Okay, let's talk about commercial speech. This is actually really easy. We just have 3 prongs. Commercial speech, advertising. Hey, if the speech is false or misleading, is it protected? No. False, misleading advertising, not protected. Okay, so what about if we have commercial speech that is not misleading? Okay, so any restriction has to advance a substantial government interest, and the regulation must be no more extensive than necessary. In other words, there must be a fit between the means and the ends of the law. Commercial speech, false or misleading? No protection. Not false or misleading? A restriction has to advance substantial government interest, and it can be, no more extensive than necessary. In other words, there must be a fit between what? The means and the ends of the law prohibiting that commercial speech. Truthful commercial speech has protection because any regulation must advance, a substantial government interest, and it can be what? No more extensive than necessary. What's a substantial governmental interest? Advertising for cigarettes on television. Can you do that on television during cartoon hour? No. It advances a substantial government interest in keeping kids from smoking. And can you advertise? Cigarette advertising is a bad example. Probably alcohol advertising is better. But the regulation can be no more extensive than necessary. So in other words, a time, place, and manner restriction would be okay. All right, let's go through our 3 prongs for commercial speech. False and misleading, not protected. And then if it's truthful, any restriction must advance a substantial government interest. There must be a fit between the means and the ends. And the regulation must be no more extensive than necessary. That's commercial speech. Okay, speech of government employees. The government may regulate the speech of government employees if they're on the job. They're acting during their employment, and in the scope of their employment. The government may regulate the speech of government employees on the job. But off the job, we get our balancing test. Whose rights get balanced against whose? That's right, the employee's rights are balanced against the government's interest in prohibiting that speech. Okay, you are a government employee. You are on the job. You are a prosecutor. You're on the job. Can the government regulate your speech? Sure they can. You are a prosecutor. You are off the job. You're speaking outside the scope of your employment. You're not speaking on a manner of your employment, but you're still a government employee. What do? We balance the employee's rights against the government's interest. Okay, couple other things. So, what if the government employee does something disruptive? Yes, they can be disciplined, they can be fired. And what if you are a member of a subversive organization that is trying to overthrow the government? Yeah, the government can refuse to hire you. But let's go through our 2 prongs. You are a government employee. The government may regulate speech if you are what? On the job. But if you are off the job, the employee's rights are balanced against the government's interest in suppressing that speech. Remember, if you are acting as a citizen, exercising your political right to free expression, that is a high bar. That is difficult to overcome. However, if you're being disruptive, or you're a member of a subversive organization trying to overthrow the government, that is a different matter. Okay, two-prong, government employees. The government may regulate the speech if you are on the job, but off the job, balancing test, employee rights against government rights. Okay, moving on. Public school students. If you are a student in a public school, your speech is more restricted. Okay, two prongs. Speech may be restricted if it materially and substantially interferes with school operations, or two, the restriction is related to, that's right, a material pedagogical objective. One, the school can restrict your speech if it interferes with the school operation. Or two, it is reasonably related to a, that's right, material pedagogical objective. What are we talking about? What would materially and substantially interfere with school operations? Well, promoting illegal drugs, profanity in school, lewd behavior in school, exposing yourself in school, would that materially and substantially interfere with school operations? Yes. Okay, so what are our two prongs? Public school students have fewer free speech rights in the public school because school authorities may restrict their rights if they are one, materially and what? Substantially interfering with what? That's right, the operation of the school. And the restriction is, that's right, reasonably related to a material, what kind of objective? Pedagogical objective. Okay, now finally, we're into the fun stuff. Unprotected speech. Obscenity. Obscenity is unprotected. What is obscene? It appeals to the prurient interest in sex. It's patently offensive. It has no literary, artistic, scientific, or political value. It appeals to what? The prurient interest in sex. It is patently offensive, and it has no artistic, literary, scientific, or political value. Obscenity is unprotected. Used to be a local standard, now it's a national standard. Okay, child pornography. Say no more. Okay, but now let's get to the really fun stuff. True threats and fighting words. A true threat is unprotected speech. A true threat is a threat directed at a person or a group of people. A true threat is a threat directed at who? A person, a group of people. It can't be satire or mere hyperbole. Threats, true threats, are directed at a person or a group of people. Fighting words. Okay, this is a great phrase to memorize. Fighting words are words which by their very utterance inflict injury or tend to incite an immediate breach of the peace. What are we talking about? Imminent lawlessness. Let's go storm the Capitol right now. Fighting words. Words by which what? Their very utterance inflict injury or tend to incite an immediate breach of the peace. Contrast to a true threat. This is a threat that is directed to a specific person or group of persons. Let's go burn down Governor Pritzker's house. That is a true threat. Fighting words. Say the rule. Words by which their very utterance inflict injury or tend to incite an immediate breach of the peace. And finally, our last area of unprotected speech, incitement to illegal activity. Okay, how does this differ from fighting words? Incitement to illegal activity has to be something that is illegal. Imminent illegal activity, someone is speaking, trying to incite someone to do something illegal, and it's likely to produce that result imminently. We could also call this imminent incitement to illegal activity, imminent lawlessness, imminent illegal activity, and it's likely to produce that result. Okay, unprotected speech. Let's say the rule. This is our last category, obscenity. It appeals to what? The prurient interest in sex. It is patently offensive, and it has no literary, artistic, scientific, or political value. Child pornography, and then we have true threats. What's a true threat? It's a threat directed at a person or a group of persons. It's not satire. It's not hyperbole. It's a true threat. Fighting words. What's our wonderful definition? Words by which their very utterance inflict injury or tend to incite an immediate breach of the peace. And finally, incitement to illegal activity. Incitement of imminent illegal activity, and it is likely to produce the illegal activity. And that is it for free speech.